Yeah, item 8 to 12, Malad.
Item
8 to 12. The pattern, the state was supposed to make the submission. There, Malad, the AG will appear otherwise. But today, at this time, is difficult. Can it, Malad, some other day convenient to this honorable court when this honorable court will be available in the regular bench?
we'll adjourn it for 2 weeks.
My lord, we will make a mention then, Malad. Whenever it is available, we will make a mention.
We'll fix it on a day when this bench is otherwise available.
Yes, yes, sir.
Item 8 to 12 be listed again when the sport is available again. Yes.
This is regarding appointment of arbitrator, my lord. Earlier, this honorable court has passed an order, my lord. Pursuant to this, if LU is more death study. Order is that, my lord. Order is that, my lord, page 53. Relevant page at page 54. That in view of the settlement of the BCC.
Yes. Thereafter,
Thereafter, my lord, some communication has been between the parties, my lord.
did you issue a notice?
Then, my lord, page 59, your lordship will see. There is a technical difficulty, my lord. Because the very claim is more than 15 crores, then, my lord, the tribunal cannot take up the matter. Then, my lord, they have asked us, page 59, your lordship, may kindly see.
Hmm.
Who does to appoint an arbitrator?
Then
My lord, I've written a letter, so I'm approaching this court, my lord, for appointment and arbitrator, my lord, as per one of the normal court.
we'll issue a notice.
Issue notice, otherwise the issue is already settled, lordship. It is more than 20%, lordship. It is 51 point, lordship, 59%, lordship. As per the
She
GCC,
is appearing, there is
That
no other party,
clauses,
my lord.
clauses 63, 64 and 47.
47. As per GCC 47, it was decided by the Honorable Supreme Court as well as Honorable Delhi High Court as well as Honorable our High Court. And
Where are the judgments?
our High Court judgment is there, lordship. If lordship permit, I can press it, lordship. The clause 47 of the GCC was upheld, lordship. It cannot be, lordship, more than 20%, lordship. Total tender value is, lordship, 28 crores 61 lakhs 40,590, and their claim is, lordship, 14 crores 76 lakhs 24,410, lordship. It was recently decided by our High Court, lordship, on the basis of the judgment delivered by the Division Bench of the Honorable Delhi High Court, lordship.
All right.
Lordship.
I'll learn in council for the batch. It's done about 2 weeks. Mr. Gogoi appears on behalf of all
All the respondents, lordship.
respondents. Since council's
Let them file
representing
an affidavit in
respondent,
that case.
notices are waived, extra copies be furnished within 1 week from today. The respondents may file their response into it. Right?
Lordship, lordship.
Let it be after 3 weeks.
Lordship.
Yes, sir.
All the lordship.
He will file the affidavit so that matter can be closed. All right.
This application has been filed for the correction of order passed in 9th of passed on 5th of June 2024 by this honorable court.
Where is the your correction? What
Uh,
correction?
Actually, the present applicant as a petitioner in arbitration petition 4/24 has filed a arbitration petition for appointment of an arbitrator for in terms of two tenders. But when the order was passed on 5th of June 2024, in terms of two tender, only one tender was mentioned in that order.
Yes, what do you say?
Yes, sir.
Two tender. What is the other tender?
The other tender was of dated 10/06/2015.
Yes. Where is that? Where is the reference?
Sorry.
Where is the reference to the tender?
NHM/PROC
Paragraph.
in the paragraph second of the present application.
Paragraph 2.
2. Page number 4.
Paragraph 2. Should be paragraph 3, I think.
Yes. There is
Yes.
of
Which-
page number 4.
Yes.
Last third line.
You read out the tender number.
NHM/PROC/RC drugs slash RSV slash 2502 slash 2015 of the 16 slash 5390 dated 10/06/2015.
So there will be two proceedings. Or one proceeding.
1% needed. Both the tenders.
Show me in your writ petition. Sorry, in the petition, arbitration petition. Page number 18 is the tender for supply.
Yes.
Page number 17.
Yes. This is for 11/11/2014. Page number 15.
Page number
15.
15.
35. 35.
Fifteen? 1-5.
35. 35.
Okay, heard. Counsel for the parties. This I has been filed. Taking correction. The order dated 5/6/2024, passed in our 4 of 2024. That the arbitration petition board of 5 6 okay. Whereby so for appointment of an arbitrator in terms of clause 27 of tenders hearing memo number so and so, page number 12. There are two numbers. and memo number so and so. Dated so and so. Whereas this court, upon hearing the counsel for the parties, by order dated 5/6/2024, allowed the arbitration petition and appointed the arbitrator, the former judge of this federal court, to act as the sole arbiter to decide the disputes arising out of the agreement executed by and between the parties. So, however, while disposing of the arbitration, the order by order did not include the numbers of both the tenders. So, in the order dated so and so, the tender notice number so and so dated 11/11/2014 was included. However, the tender notice number so and so dated 10/6/2015 was not included. Stop. This I has been filed by the applicant seeking incorporation of the tender number. Since the arbitration petition so and so was filed seeking with a prayer for appointment of an order, appointment of an arbitrator in terms of section 27 in respect of the disputes arising between the parties in tender number so and so dated 11/11/2014 and tender number so and so dated 10/6/2015. So, whereas counsel for the respondent does not dispute the submissions of the counsel for the applicant. So, and upon hearing the counsels for the parties and about careful perusal of the same, this court is of the view that since the prayer in the arbitration petition was for appointment of an arbitrator in respect of tender number so and so dated 11/11/2014 and tender number so and so dated 10/6/2015. Whereas the order dated 5/6/2024 passed in arbitration petition number so and so was disposed of, allowing the petition and appointing the arbitrator only in respect of tender number so and so dated 11/11/2024, comma. This IA stands allowed. Stop. This order dated 5/6/2024 passed in arbitration petition number so and so, appointing Honorable Mr. Justice so and so retired to act as the sole arbitrator, decided the disputes arising out of the agreements executed by and between the parties in respect of tender numbers so and so dated 11/11/2014 will now be read. Will now be read together with this order. So, the sole arbitrator appointed is also required to decide the disputes arising between the parties in respect of tender notice number so and so dated 10/6/2015, along with the tender notice number so and so dated 11/11/2014 had already been directed. So, accordingly, this order shall now be read together with the order dated 5/6/2024 passed in arbitration. And wherever the reference of tender notice number so and so dated 11/11/2014 appears, the same shall be read as so and so tender notice number so and so dated 11/11/2014 and tender notice number so and so dated 10/6/2015. So, This IA therefore stands allowed in terms of the above directive. The arbitrator is permitted to proceed to decide the disputes arising between the parties in respect of tender notice number so and so dated 11/11 and tender notice number dated so and so 10/6/2015. IA accordingly stands allowed in this. Where did we leave last time?
We have completed our argument.
Like there.
I started, I placed some judgments also. Lordship asked me to obtain instruction with regard to one notification placed by my learned Syrian friend. That was dated 13/3/2019, where some authorities have been prescribed.
Some?
Some authorities have been prescribed, designated authority,
Ah.
who can supply the information. But Lordship, the matter is relating to 2017-18. In this case, Lordship, 148 notice was issued on 31/3/2017. And the present notification that placed by landed friend, it is dated 13/3/2019. So the situation was different before 2019.
Yes.
And section 147 and 148 was also amended in 2021. And at the relevant time, Lordship, section was also before amendment law.
Where is that notification?
But that was placed in the record by my learned senior citizen. It is dated 13/3/2019.
Page number?
It was loose copy was supplied by learned. Notification dated 13/3/2019. Paper book only.
So your submission was that the inputs which had come did not come from this designated authority,
This did not come from the prescribed authority.
prescribed authority.
Our submission was this section 133C was introduced with effect from 1/10/2014. And till 2019, no authority was prescribed. And what they are relying upon is that the DI investigation, the information which they received from DI investigation was received under section 133C, whereas he was not the prescribed authority. As per notification dated 13/3/2019, for the first time, the authority was prescribed is Commissioner of Income Tax, Delhi, e-verification. So when they relied on
Just one minute. Yes.
Your Lordship will kindly see at page 119 of the writ petition. Hundred and nineteen, my lord.
Yes.
Now, I'm reading from the top. It may also be stated here,
119
119
annexure 4
of the writ petition, my lord.
writ petition. The writ petition only.
This is annexure 17.
Which number are you? Which
I-
writ petition are you?
Lordship Mukund Infrastructure, WPC number 7103 was taken as a lead case.
Oh, 7103.
71.
Yes. Yeah. Okay, yeah. Along with that. Yes. 119.
119. This is part of annexure 17, my lord, where my objections were rejected by the assessing officer. Now it says, it may also be stated here that as per provisions of section 147, explanation 2CA to section 147 states as follows, quote, where a return of income has not been furnished by the assessee or a return of income has been furnished by him, and on the basis of information or document received from the prescribed income tax authority under subsection 2 of section 133C, it is noticed by the assessing officer that the income of the assessee exceeds the maximum amount not chargeable to tax, or as the case may be, the assessee has understated the income or has claimed excessive loss, deduction, allowance, or relief in the return, unquote. Then it says that in the instant case, information has been received from Directorate of Investigation that the company Mukund Infrastructure has raised capital to the tune of so and so. Now they are relying on explanation 147, explanation 2CA of 147. Now it refers to section 133C. Now the notification that has been placed before your lordship,
Yes.
the notification that has been placed of 2019,
Yes.
for the first time,
Yes.
the prescribed authority under section 133C was authorized as per 2019 notification. And that also it was the Commissioner of Income Tax, E-Verification, Delhi.
Uh,
Now, the Directorate of Investigation, which they are referring to, was not the prescribed authority. Therefore, whatever information has been received from Directorate of Investigation cannot be treated as an information as mentioned in explanation 2CA of 140.
all right. By and large, we have heard you.
Now,
Now,
since he raised the issue, I am
Mr. KL, are you submitting any written argument?
Lordship, I can submit a written argument.
You submit it. Hello, we'll go through it, and then if there are further queries, we'll list it for one day, and then
Lords,
reserve it.
by Monday I'll file.
Have it over to the
Yes.
court martial.
Lords,
Then
Lordship, we were directed to file synopsis of all these cases, along with the synopsis of case laws which we have submitted already in the compilation. I have, can I submit the notice?
Yes. We'll give you some more time. We'll list it on 6th.
Lots. Before
Take
that,
your time, prepare it, give it to us.
lots.
If time permits, we dictate it here or we'll reserve it. Hard Learned Council for the party. Matter listed again on 6th of August for further hearing. Meanwhile, the councils for the parties are permitted to file the written arguments. You are submitting it today.
My lord,
Submitting it today.
I am
Please hand it over to the court. 6th of August.
submitting.
The court.
My lord, the government was to take the instruction. They were deducting at source of 2%, which they cannot because it is
Over and
the
above.
recipient of the last services, it is its obligation to pay. As last recipient of this service, GST is payable by the government. There's no question of, we being laden with all these liabilities. No, at least
You are
other
supposed
deduction
to-
করবো না লাগে.
you are supposed to give us instruction.
Yes,
Your
Matlab
instruction.
they should not make any further deduction. Exactly.
Will be settled. This case will have some wider implication. That's why I'm paying for some time now. Department is also considering the matter. If in one case this order is passed off, then it will open the floodgate.
It's not a question of floodgate. If you're pursuing a wrong thing, then it is to be corrected.
Secondly, Dr.
Every case need not be opposed by lot. Here is a open and shut case where they should add the value of the GST in the price. That you are not doing.
So far as our understanding is, Lordship, GST is inclusive of everything. I mean, the bill amount is inclusive of GST. But that is the stand in the affidavit. I'm not.
If that is so, my lord, please come to page 183 of the petition. 183. Page 183. That's part of the
Same work.
additional affidavit. Page 183.
X.
Yes. The rates quoted by the contractor shall be deemed to be exclusive of the good and service tax. It is your document. Yeah, different component.
Mhm.
That is in respect of a work with Northland Constructions Private Limited.
Insofar as your contracts are concerned,
Yes,
that was
inclusive, but there is a last line.
pre-GST.
No, post GST, but they did not correct it. But there's last sentence.
Ah.
If your lordship will kindly come to page number 103. The rates quoted, as the lordship got it, the rates quoted by the contractor shall be deemed to be inclusive of sales tax and other levies, duties, royalties, cess, toll, taxes of central and state government, local bodies, etc., etc. The last sentence, the employer will perform such duties in regard to deduction of taxes at source as per applicable law. And this GST regime came from 1/7/2017. And this contract was post that period. Tender was on 18/1/19. And the notification is also there issued by the Government of India at phase 177. Lordship will kindly come to 177. D, category D. What they are supposed to do in cases of all new works to be proposed under PMGSY, the state shall prepare schedule of rates after deducting taxes subsumed under GST. Now, 2 is important. The detailed project report shall be prepared based on this revised SOR, and the state may add 12% GST to the cost of the work to arrive at the overall cost of the work. This they have not done, Miller. That's why this problem is happening. Subsequently, they are doing as is evident from the other contract.
You have filed your pleadings here? No.
Yes, I have received
They-
instruction, Lordship. Lordship, one
They have filed.
standard billing document for PMG as well. Lordship, one clause 13.3 is there. And it states, Lordship, all duties, taxes, royalties, and other levies payable by the contractor under the contract or for any other cause shall be included in the rates, prices, and total bid price submitted by the bidder. That is what we are.
My lord, we can't debate on an issue whether sun rises in the east or the west. There cannot be any debate on that. There cannot be any debate on section 9(4) of the act. If somebody has not understood, this is not the problem of the citizens, Miller.
If we at all have to discuss about the act law, then GST is a necessary part.
GST বলে কেউ বস্তু আছে?
We can require the GST can be made a party. There's no
There's
difficulty.
no question of GST. GST by itself is not a, my lord,
no,
Income Tax
GST.
Act is not.
No, GST authority. Because This
The
may
state
require-
GST authorities are there. Well, the section 9(4) is very clear.
Yeah, referring to section 9 of GST Act. That's good. Somebody should be there from the GST authority to interpret or.
it is for you to decide, it is your contract.
Supposing, my lord, in a case,
When I'm following the
supposing, my
contract,
lord, in a case of,
If you have not understood the import of 9(4),
Ah.
then
The form is also.
You- if you want-
Contract agreement. For me, it's a
contract
contract.
agreement can't be
and I-
contrary to the
statute.
laws of the statute. If it is in conflict, you have to resolve it. Whether you want to resolve it in consultation with some
No,
department or not.
Once there is a contract agreement on.
Correct, but if it is,
Signature of both the parties, then where is the scope for?
no. But then it can be in conflict with the laws. There is a change of law. Earlier concept was different. With effect from 1/7, there was a complete change of
GST
the
regime.
regime. We can request the GST council to enlighten us. There's
Oh,
no
yes,
difficulty.
that's a different issue, my lord.
You tell us when it would be convenient. We can-
Only thing is, my lord, they should not make any further deduction. নতুন
If
দিল্লি
any deductions are made, let it be subject to the outcome. That will.
No,
from GST might.
No, my lord, what will happen in that case, the amount will be deducted and they're depositing. And nowadays, my lord, it
If
is,
we grant you a stay and they don't,
what I'm saying is they should not make this 2% deduction
that's what I'm saying.
from my other bills.
If they don't do it,
Hmm.
if they don't deduct, if we permit you, we grant you that interim, and tomorrow, for some reason we disagree with your view, then there could be other responsibilities settled on you from GST.
Then we can always be asked to compensate that the undertaking we can give Millard. In the event the case is decided against us, we'll return.
My submission will Lordship will hear this matter finally, Lordship will fix it for me. Till then, Lordship,
Whatever. has been-
In this case, I don't
whatever
think
has
there's
been
anything
deducted
left to be
will make it
decided.
Subject to the.
They will have
outcome.
to make provision for that 12% addition in their bill value, then everything is solved.
like if my learned colleague thinks that his arguments is the sole base, should be the sole basis for deciding a case, Lordship, then I have no case, Lordship.
No,
I
but
leave it to
he
your
is
Lordship.
entitled to
And
make
if
a
your
prayer.
Lordship thinks that my
He
argument
is
also,
entitled to make a prayer. We can't stop him from making a prayer. Can't be aggrieved because the council makes a prayer. That's what councils are there.
Every time my landlord friend says we are not entitled to a relief, can you stop him from making that, my lord? We never did that. Even now he is making an argument against us. So we are not stopping him to make that argument.
We will make it subject to the outcome of the writ petition, or we'll keep this question open if required to be decided on a later
So
stage.
my lord will do this, my lord, subject to the outcome and secondly at an early date.
Here, K.N. Chaudhary, Colonel Senior Counsel, assisted by Mr. Rajendra. Mr. Nayobi, Nayob, hearing for the respondents. The matter will require further hearing. Therefore, the councils, the respondent council submit that matter be listed.
Since affidavit is exchanged, my lord, everything is ready.
Listed hearing on 6th of August. Will
My lord.
next of Meanwhile, any deductions made for GST from the bills of the writ petitioner shall be made subject to the outcome of the writ petition.
Different.
List on 6th.
apply.
May it please your lordship.
Ah.
On last occasion, your lordship had asked the queries regarding which department, my lord, grant permission for cutting soil, my lord. This is the instruction I have received.
Who's for the respondent? Who's for the petitioner?
I'm for the petitioner in item number 19, lord.
So who's for petitioner in 18?
One is
None appears for the writ petitioner in item 18. MS so-and-so appears for writ petitioner item number 19. So, there are, on the last date a query was raised, query was put by the court. The learned government council as to whether any permission is required to be obtained from any authority before. In respect of prior to undertaking artwork, so the learned standing council soil conservation has submitted on basis of instruction that prior to artwork, An application is to be filed before the office of the district commissioner of the concerned district. And a permission to that effect has to be granted by the district of. The procedure followed is that upon an application filed before the district commissioner of the concerned district, a joint verification is conducted by the Assam. Joint verification is conducted with the Assam Forest Department, and then the same is forwarded to the Department of Geology and Mining. Of Geology and Mining, thereafter seeks environment clearance from the State Impact Assessment Authority, and after obtaining necessary clearance, permission for soil cutting is granted by the district commissioner of the concerned district. Para. Since the learned counsel for the petitioner in item number 18, the PPC is not present, and the dispute between the writ petitioners in WPC in item 18 and 19 are with regard to the and the grievance of the writ petitioner in item 19 is that the writ petitioner in item 18 is resorting to undertaking artwork near the residential house of the writ petitioner in item number 19, and which has the potential of putting the entire house and the residents of that house, including the writ petitioner, to danger, and the complaints made before the authorities have not been redressed. Petitioner is before this court. So, in view of such questions raised before the court, query was put to court, which the learned Standing Council Soil Conservation has submitted today on the basis of instructions received. You want to bring it on an affidavit?
Sure.
The learned Standing Council is permitted to bring his instruction by way of an additional affidavit, which he may file after within 2 weeks. Accordingly, the matter be listed after 2 weeks, enabling the Standing Council Soil Conservation.
Lordship, on the last occasion, DMD was also called for.
Let them come. File necessary affidavit. List accordingly.
Published.
You said it was covered by Lordship, order, similar order passed by this court. Bhatek,
What it, Lordship?
what do you say, Mr.
Facts.
Chaudhary?
Facts are slightly different, Lordship.
Facts are different, Lordship. In that Vatek, there was a representation by the authority, by the petitioner before the authority, stating the reason for their delay in submitting the refund application. And the rejection, Lordship, directed that it was not it was not a reasoned order.
Now here what happened?
Here, Lordship, they have created a presumption that what has happened that my cases were taken up for audit estimate, but it was not completed within due time. subsequently, when I filed a refund application, it was processed, and depending upon the quantum of the refund from the office of the Assistant Commissioner, it was sent to the Deputy Commissioner and to the Commissioner of Taxes. At that stage, they rejected, saying that because audit assessment was not completed, so the
Where is the impugned order?
ultimate turn to page WPC 1430 of 2017.
1430. Yes.
Page 36, Annexure 5. May I read?
Yes.
Subject refund for the year 2006-7 under Assam VAT Act. Your refund application dated 28/10/2016. With reference to the above, you are hereby informed that as per provision of Section 50 of the Assam VAT Act, that with Rule 29 of the VAT rules, you are to apply for refund within 180 days from the date of assessment or reassessment. In your case, as no audit assessment was made within the time limit of 5 years, that is 31/3/2012, hence it is presumed to be a case of self-assessment. Therefore, you should have filed your refund application on or before 30/9/2012, but you failed to do so. In view of the above position, I have no other alternative but to reject the refund application being filed. So here they have created a presumption which I possibly cannot presume at an early date. Once the audit assessment was taken up, notices were issued, I proceeded and participated. It was not completed in due time. Now, since you're not completed, they are presuming a for situation where I go back in time and I filed a refund application. And this is the only not the case, Lordship. What is the different stand they have taken? I just prepared this tabular for your Lordship's perusal.
No, what? Yeah.
It's for Lordship 4 read petitions for 4 different periods.
Hmm.
My second column is assessment year. That's for 6, 7, 7, 8, 10, 11, and 9, 10. Lordship may come to for 6, 7, the first column. Notice for audit assessment under section 36(1) was issued on 28/5/2019 by the VAT audit cell. There was no subsequent proceeding in that. 7, 8 notice was issued for audit assessment on 21/2010 by VAT audit cell. It was not completed. Thereafter, they again issued notice for best judgment assessment under section 37 on 21/9/2010, again by VAT audit cell, but it was also not completed. My refund application for these years were filed on 28/10/2016 and 31/3/2016. Coming down to the rejection order, the reason, as I've just read to your Lordship from Annexure 5, as no audit assessment made within 5 years, it is presumed to be a case of self-assessment. So, refund application should have been filed within 30/9/2012, that is 180 days after 5 years. Here, what they have done is
What is the time limit for completion of audit assessment
5 years from the end of assessment year.
after issuance of the notice?
After issuance of the notice, also it's 5 years. The outer limit is 5 years.
5 years.
Lordship.
But it was not completed.
Not completed. Now, for the time being, Lordship may come to the third column and the fourth column. That is for the period 2009-10 and 10-11. Here, my application of a refund was filed within after 5 years. That is 31/3/2016 and 28/3/2016. Depending upon the quantum, it was forwarded to the Deputy Commissioner of Taxes on 23/8/16 and 11/5/2016. Now, here what they have done is they have taken a different stand.
Now tell me one thing.
Lordship.
Once you file your returns,
Lordship.
when did you realize that you are entitled to a refund?
In the return itself. I have claimed my refund in the return itself.
Return itself.
Yes.
Then why did you not file your application?
Because the procedure is, in my return, there is a column, the refund claim. So I have already claimed my refund in the return itself. It is the usual process of the department that they take up the
No,
assessment.
there are different dates of claiming refund application.
Yes, yes, Lord.
Uh.
Different dates is because I had waited for the assessment to be completed. Usually the department completes an assessment within 5 years, or the assessment by assessment. And there is also a scope for escape assessment, which the department has the power to complete till 8 years of the end of the assessment year. So as a usual
But
practice,
that is your presumption. If you had already claimed for refund,
Lord said,
and if there was no audit assessment, you should have pursued this matter saying that I'm entitled to refund, please give it back.
no, in absence of assessment order, I am not supposed to file the refund application separately. Because the provision of refund application reads as such.
This is on the VAT.
Lordship. Lordship will come to section 50. Provide for refund. Here lies the whole contention of my petition. Mary,
Yes.
subject to other provisions of this Act and the rules made thereunder, if it is found on the assessment or reassessment, this is the important line, Lordship. If it is found on the assessment or reassessment, as the case may be, that a dealer has paid tax, interest, or penalty in excess of what is due from him, the prescribed authorities shall, on claim being made by the dealer in the prescribed manner and within the prescribed time, refund to such dealer the amount of tax, penalty, and interest paid in excess by him. So it is on assessment or reassessment. Once the authorities complete an assessment or reassessment and they determine my refund application amount, then I'll, as per the provision, I have to file a refund application. Provided that such refund shall be made after adjustment of the amount of tax or penalty, interest, or sum forfeit. This is not relevant, Lordship.
Let us see the rules.
Rules is 29(1)(a). Rule 29(1)(a). As a Lordship for Rule 29.
29(1).
1A.
Hmm.
The application for refund as referred to in subsection 1 of section 50 shall be made in form 37 within 1 year or within 180 days from the date of assessment or reassessment as the case may
From
be.
the end of the relevant tax period.
So there was a subsequent amendment to that, Lordship.
Oh.
I'll produce this book, Lordship. This covers the amended part.
Yes.
Running page
Oh, no.
304, Lord.
Yes.
So this covers the from the date of assessment or reassessment as the case may be. Proviso. Provided that an application for refund made after the state period may be admitted by the prescribed authority if he is satisfied that the dealer had sufficient cause for not making the application within the state period. Then the reason for rejection, if of the refund application the authorities are inclined to, the reason has been specified in clause C. There cannot be any other reason for rejection of refund application. The prescribed authority may reject any claim for refund if the claim file appears to involve any mistake apparent on the record or appears to be incorrect or incomplete based on any information available on the record after giving the dealer the opportunity to show cause in writing against the rejection. So in this case, what has happened? While filing my return, I have claimed my refundable amount, which was the tax deducted at source while executing the works contract. The contract department has deducted my tax at source and deposited. This excess amount of deduction is refundable to me, which I have claimed my return.
Then there was no assessment.
There was no assessment,
Then
but my claim is already stands in the return.
no,
And
if
when they
you
have
are-
taken up the assessment
if you are
procedure,
relying on 29(1), if you are relying on rules 29,
not it.
this is very clear that from the date of assessment or reassessment,
True,
180 days
True.
from the date of assessment or reassessment.
now for that time being, Lordship has come to the provision of self-assessment. Which your Lordship will find at page 90, section 35. Because the ground of rejection, they are saying that your return has been treated as self-assessment. Now, when it will be self-assessment? Page
Yeah.
35.
Yeah.
The amount of tax due from a dealer liable to pay tax may be assessed separately for each year during which he is so liable, provided that the Commissioner may, subject to such conditions, if any, as may be prescribed, assess the tax due from any dealer during a part of the year, and the other provisions of this section shall be construed accordingly. If a dealer has filed all the tax returns and the annual returns or revised returns in the prescribed manner and within prescribed time, and has paid the tax payable according to such returns or revised returns, and also interest payable if any, the returns or revised returns so filed shall be accepted, and his assessment shall be deemed to have been made for the purpose of subsection 1, subject to adjustment of any arithmetical error apparent on the face of the state return. Provided that the assessment under this subsection of every such registered dealer who is required to furnish audit report under section 62 shall be deemed to have been made if such dealer has furnished the audit report along with the annual return.
You filed your audited report. Did you file your audit?
Not within time limit. For that, the audit assessment notice was issued and the audit assessment was taken.
Yes.
Because along with, although we filed a return, we have to file certain certificates, the tax deducted at source and all those things, which take certain time. Because of this provision, Lordship, although it is treated as self-assessment, but under the usual proceedings of the department, I cannot presume it's self-assessment unless they complete a regular assessment, which they usually do in case of refund application. And similarly, they have taken up the refund assessment for refund application for the period of 2006, 7, and 7, 8. So far, Lordship, the refund amount is concerned, there is no dispute to that. The department doesn't dispute the refundable amount. Only the thing is they have drawn a presumption at a later stage, and they are taking a date that I should file the refund application, which according to me I should not have filed because I have already claimed in my return.
Then what is there in this other order? Order.
In
What are the facts there? Yeah.
in Patek, In Vatek Lordship, what has happened? They have filed a refund application, but that was not within the record of the department. So department has asked them to furnish a proof that you have filed the refund application. The petitioner could not furnish that, and it was presumed that they have not filed it, and subsequent refund application which was made by the petitioner was treated as time barred. For that, Lordship may turn to paragraph 5 and 6 of the order. Five, 6, and 7.
What is the position of refund in so far as matters where the assessments are not completed? Or in matters of self-assessment letters?
If the time is over, Lordship, then the refund application should automatically process. Provision doesn't say in respect of situations where assessment is not complete. Refund application, the provision simply says about the assessment. Now, so far self-assessment is concerned, it has to be accepted. The words are very clear in subsection 2 of section 35. So acceptance of the department, they have to come to a conclusion of assessment or scrutiny of the return. Even if I go by the stand of the department that I should have filed the refund application on such
You don't
date.
deny their refund.
Yes. There is no denial of the refund, but the application they have made for refund application was beyond the time limit prescribed by the Act. And Lordship, in the
Is there no provision for condonation?
No outer limit, Lord.
no,
There is no outer limit. Provision says section 29(1), rule 29,
subject to the satisfaction. Lordship. 29(1)(8)
proviso.
proviso.
180 days
180 days is the
within
But beyond delay
after
also,
the said period.
yes, subject to satisfaction.
So there is a provision.
Yes.
But there is no outer limit to that.
What
If-
outer limit?
Outer limit, it's not that beyond 180 days again after within 100 days only or like that.
That's okay.
So if at all they found that it was delayed, so there was
And
apparent
what was
reason.
the order passed here by the department? Rejecting your refund?
Lordship, that is Annexure 5, page 36.
it did not consider the grounds that, I mean, whether the grounds urged by the petitioner were reasonable, unreasonable, thing is there.
That's
So there was no stage, Lordship.
Hmm?
There was no stage of giving the grounds, Lordship. I have made my refund application. They have processed it. After processing, subsequently they rejected with this order.
Where is your refund application?
Is page 34, annexure 4. Page 34, annexure 4. It starts from, sorry, page 33, Lordship. Page 33 starts with the forwarding letter, then the refund application.
Where is the refund application? 34.
34 is in the format of Form 37 as prescribed under Rule 29.
You also did not explain in your forwarding report, you did not mention that
there was no application.
No, that stage doesn't arise when I'm filing the refund application. That stage arises subsequently when they find that I've found it with delay. Then they have to call a reason.
what do you mean you are filing this refund application on the ground that it is a self-assessment. Taxes have been submitted under the
Yes,
by self-assessment.
yes.
So
When the period of completing assessment, provisional assessment by the department is over. Period of 8 years is over.
within 180 days.
And what is
180 days, Lordship, is from the date of assessment or reassessment.
Where is the provision for refund?
Section
50.
50. Section 50.
No, these 180 days from the date of assessment will be counted as what assessment?
Audit assessment, bad judgment assessment, and escape assessment.
What about self-assessment?
Self-assessment will come subsequent. If they have not completed those assessments, then it will be self-assessment. It has to be accepted by the authority, Lordship. There has to be an order that your return has been treated as self-assessment. Lordship again turn to self-assessment provision, Lordship. Page 90, section 35. Subsection 2. Page 90.
Yes.
Subsection 2. If a dealer has filed all the tax returns and the annual returns or revised returns in the prescribed manner and within the prescribed time.
You are reading from page 19.
Page 90.
90.
Section 35. Section 35, subsection 2.
Yes.
If a dealer has filed all the tax returns and the annual return or revised returns in the prescribed manner and within the prescribed time, and has paid the tax payable according to such returns or revised returns, and also interest payable if any, the returns or revised returns so filed shall be accepted and his assessment shall be deemed to have been made for the purpose of subsection 1, subject to adjustment of any arithmetical error apparent on the face of the state return. So it's not simply that I filed a return and it is treated as self-assessment. It has to be accepted by the operative. They have to go into the correctness of the returns file.
It will be deemed to have been accepted. It is deemed to have been accepted.
Deemed to have been accepted.
So from that day, within that
Assessment
100
proceeding has been reopened in the audit assessment.
Hmm?
Assessment
but
proceeding.
it did not proceed, it did not culminate into any further assessment, reassessment. Only a notice was issued.
No, when the audit assessment is opened up, then there is no more self-assessment.
Why did it proceeds further and culminates into a audit assessment? Did not. Only a notice was issued. That is your submission.
Yes, notice was issued, proceeding was started.
Then it did not
We
culminate into
participated
an
in the
order.
proceeding.
It did not culminate into.
It did not culminate.
So what happened? What remained? The
Once it
self-assessment.
is started, we waited for 5 years.
You may have, but the self-assessment remained.
It remains. It remains, but it got finalized because that assessment was not completed. If that assessment would have been completed, it was no more a self-assessment.
When was the notice issued?
Notice for self-assessment.
No.
Audit assessment
Audit.
was on 28/5/2009. Annexure to page 31.
Did you appear in person before the authority?
We appeared. And we also filed a representation, which is page 32, where we have stated that here the notice was for 2 periods, 2005, 6, 6, 7, and we stated that 5, 6 has already been completed, so 6, 7 may be proceeded. And after that, we appeared before that. That is a part of the case record with the department.
Yes, Mr. Chaudhary, what do you say?
As Lordship has rightly pointed out, in those cases where audit assessment notice was issued, but it didn't proceed further, it's a case of self-assessment, and from the date the financial year ends, Lordship, he is required to file the refund application because it's already reflected in their return. And in case of the other 2 cases, Lordship, there was no audit assessment notice or anything yet. Lordship,
No, but what is your stand of the department?
Uh,
Has the audit
department-
assessment proceeded? Was there an audit assessment?
Lordship, in 2 cases, it didn't finalize. Our stand is that Lordship, Lordship, our stand is that he submitted the application for refund after the statutory period as prescribed by the Act.
Which statutory period for what?
For
Starting
filing
from which date? You are counting the date from which period? In respect of which assessment?
Lordship, in all of the orders, it has been reflected. Lordship, I'm taking up 2833, Lordship.
Why don't you take up this matter? Which is hard.
Yes,
1430.
here, Lordship, page 36. With reference to the above, you are hereby informed that as per provision of section 50 of the ABAC Act, 03 Rule 29 of the ABAC Act, you are to apply for refund within 180 days from the date assessment or reassessment. In your case, as no audit assessment was made within the time limit of 5 years, that is 31st May 2012, it was in case of 2006, 2007 assessment year. Hence, it is presumed to be a case of self-assessment. Therefore, you should have filed your refund application on or before 30th September 2012. It's the end of the accounting year, Lordship. Assessment. From that date onwards, Lordship, the time limit as prescribed by the Act will
But that is his information you have given to him after the time limit has expired.
Yes, on the
He waited for the assessment to be completed pursuant to your notice. Then you dropped the proceedings or did not pass an order.
nothing was there, Lordship. And only on the his making of his application, Lordship, it was processed, then it was found that it was beyond that time.
Are you relying on any judgment or any proposition?
Lordship, one is the Lordship's order in Batek only, because where otherwise finding the refund application, the reasons for rejection, Lordship has directed them to consider. Then I'm relying upon this persuasive precedent, Lordship, High Court of Tripura. Nandini,
Okay, we'll keep it for 29. Pass orders on that. Sorry, not 29. 30. 30th of July for orders.
the judgment I'm relying upon is from High Court of Agartala, Tripura. That's Nandini Impact. In this case, the assessment was time barred and was not complete. Similar fact, Lordship. Then the refund application was rejected, which the Honorable Court has stated is not permissible.
All right.
And another one is, Lordship, I have given is High Court of Delhi in the case of Pool Floyd. Sorry, Lordship.
What about Tata Chemical?
Tata Chemicals, Lordship. I have relied upon Tata Chemicals. That is in case of interest on refund, Lordship. That is a statutory provision otherwise. And the Honorable Supreme Court has stated when there is a statutory provision and the refund is due under the tax act, as per the provision, the interest is also due.
Okay. So Chaudhary, anything?
Lordship, I'm relying upon I'm relying upon the only provision. Lordship.
All right.
Interest on refund is, Lordship, section 52, that's the statutory provision.
Okay. 29. It's on 29. Heard learned counsel for the parties. Matter will be listed for. We'll keep it for hearing, but we'll pass orders on 29. It will be listed for hearing on.
Lordship,
Further hearing
38.
on 39. On 30th.
38.
30th. Pick it up, okay. Okay.
Much of it. Yeah, ৰাখিলো সেইটো নাই নেকি এইটো ফাইলৰ লগত থাকক এইটো ফাইলৰ লগত থাকক লাগিব পাৰে এইটো পঢ়াৰ কাৰণে ফাইলৰ লগত থাকক দৰকাৰ জাজমেণ্টৰ পিছত মই লৈ ল'ম ৰাখিব নোৱাৰি কিন্তু এতিয়া বস্তু এনেকৈ প্ৰিজাৰ্ভ মই backdated গৈ how can I do something or undo something by going in a backdate? I try to keep it. But, excess deduction was backdated now.
है क्या? सर एक्सरसाइज होगा कि नहीं? आज नहीं होगा।